If you're looking to start freelance consulting, did you know that there are several legal issues that could actually prevent you from starting your consulting business? In this episode, I'm going to be breaking down 7 areas of the law that you must know before you start your consulting business to avoid getting into legal trouble. My name is Brandon Michaels. I've been an IT consultant for over 2 decades, but more than that, I'm also a lawyer, and I've used my legal knowledge to avoid many pitfalls and successfully build a multi-6-figure per year freelance consulting business. Now, before we go on, I need to say this video is for educational entertainment purposes only and is not meant as a substitute for legal advice. If you have specific questions about a legal matter, you should consult an attorney who's licensed in your state. Having said that, the first legal issue you need to be aware of is the non-compete agreement. Now, what is a non-compete agreement? This might also be called a non-competition agreement or covenant not to compete. If you've signed a non-compete agreement, what this would do is prevent you from starting or working for another company that offers the same products or services, or even similar or competing products or services from the company that you signed the agreement with. So let's say you work for an employer and you're thinking of starting your freelance consulting business. If you've signed a non-compete agreement, you're not going to be able to go out and do the same kind of work, offering the same kinds of products and services if you've signed this non-compete agreement. Now, there's a 3-part test to determine whether or not this non-compete agreement is enforceable. Generally speaking, the first part of this 3-part test would be, is this agreement time-bound? What does time-bound mean? Time-bound means that it can't last forever. It needs to be restricted to a certain amount of time. A very common time period that you might see in some of these non-compete agreements would be 1 year. So let's say the non-compete agreement that you signed prohibited you from carrying on business that would compete with your current employer or your former employer for a period of up to 1 year. That would be something that is time-bound. The second part of the test is it also needs to be geographically bound. What does that mean? Geographically bound means that it can't go everywhere. It can't extend everywhere. It needs to be within a certain area. For example, a city or a metropolitan area, or maybe even a region. And with both of these, they must be reasonable limits. They must be reasonable restrictions. And the third part of the test is that it must protect a legitimate business interest. Protecting that legitimate business interest would prevent you from taking the information you knew from working with them or working for them and using that against them in terms of competition. Now, generally speaking, if a non-compete agreement meets this 3-part test, it would be fully enforceable. However, non-compete agreements are governed primarily by state law. So even though it may be federally enforceable, the state law is ultimately going to be what governs that agreement. For example, even though non-compete agreements are legal throughout the United States, the state of California prohibits them. So in the state of California, you can't have a non-compete agreement with certain exceptions, very narrow exceptions. And what does it mean to be fully enforceable? That means that if you sign a non-compete agreement and it passes the tests that it needs to in order to be enforceable, if you violate the agreement, the company with whom you signed the agreement can actually sue you. And if they win the lawsuit, you would be liable for monetary damages. They could be significant. Now, in some interesting recent news, the FTC recently ruled that non-compete agreements are completely invalid. However, shortly thereafter, a federal district court struck down the ruling, saying that it was arbitrary and capricious. Basically, what they said was the FTC did not present enough evidence for such a broad, sweeping rule that would affect every business across the entire country. As of the recording of this video, the FTC has not appealed that judgment. However, I'll be paying attention to that, and if anything further develops, I'll make sure to report it back here. Now, the next legal issue you need to be aware of before you start a consulting business is the non-solicitation agreement. The non-solicitation agreement is similar to the non-compete agreement. However, it has a different intent. A non-solicitation agreement, if you sign one, would prevent you from approaching your employers, your former employers or current employers, customers or clients, or even any employees who work for that company. For example, let's say you go out and you start your freelance consulting business. If you've signed a non-solicitation agreement, that means you can't go after that employer's customers or clients. You couldn't try to take business or get business from those customers or clients. You also could not try to go and poach employees from your former employer, meaning that you couldn't try to hire them away and have them work for your company. Now, just like the non-compete agreement, the non-solicitation agreement also needs to be reasonable in scope, meaning reasonable in time, time-bound, has to be a definite period of time that's not unreasonable, also has to be geographically bound. So again, it can't extend everywhere. It has to be a limited area that's reasonable. Now, just like with non-compete agreements, state law governs with non-solicitation agreements. So for example, in New York, in addition to being time-bound and geographically bound, it must also protect a legitimate business interest. Legitimate business interests could be things like intellectual property. What's intellectual property? Intellectual property is generally broken down into 4 categories. There's copyrights, patents, trademarks, and trade secrets. So if the company had you sign a non-solicitation agreement to protect one of those kinds of interests, one of those intellectual property interests, that would be something that allows them to pass this test. Could also be protecting employees with specialized skills. So if, for example, your former employer has employees that have highly specialized skills that allow them to conduct business in the way they do, that gives them some kind of an advantage in the market, you would not be allowed to hire away those particular employees. If you knew a janitor that worked for your former employer and you needed some janitorial work, and maybe you have some office space and you want someone to clean it and take care of things that break, that's likely not going to be someone who has specialized skills for the business. Specialized skills would be things that are particular to how that business runs. Also in New York, a non-solicitation agreement must not create any undue hardship. An example of undue hardship would be preventing someone from soliciting customers anywhere in an entire state for the period of several years. Again, speaking to the reasonability standard, in this case, if you're able to prevent someone from going after customers anywhere in an entire state for several years, that would likely force them to uproot their life, their family, and move out of state. And that is very likely to be seen as undue hardship. And additionally, in New York State, it must not cause harm to the public. Classic example here is, let's say a doctor works for a medical group in an area that's underserved, that basically doesn't have enough doctors for the population. And if he were to leave and start his own practice, wanting to serve in that same area and maybe bring some other doctors in to provide even more medical services in that area, if he were prevented from doing so, that would cause harm to the public, because in that underserved area where they need more doctors, preventing him from opening another practice and providing more medical care would cause the people in that area to suffer. Now, the third legal issue you need to understand before you start your consulting business is the non-disclosure agreement, or the NDA. This is something you likely heard of before, maybe even signed before. Like the non-compete and the non-solicitation, this also is legally binding and fully enforceable under the law. It's something that normally would be signed by employees, vendors, contractors, anyone that the company would want to prevent from divulging information that they don't want divulged. And the reason for this would be to protect business information. Again, intellectual property, customer lists, product information, company growth plans, things that are strategic, things that a company would not want their competition to know. Now, one thing that's important to note with non-competes, non-solicitations, non-disclosures, as with any contract, and that's really what an agreement is, it's a legal contract, as with any contract, it cannot ask you to do something illegal, or it cannot prevent you from reporting something that you're legally obligated to. Now, generally speaking, under the law, there isn't an obligation to report illegal activity. However, in some jurisdictions, some criminal or illegal activity, you are required to report. So in this case, a non-disclosure agreement could not act as a gag order that prevent you from speaking up when you need to or when you're legally obligated to. Now, the thing about the non-compete, non-solicitation, and the NDA is they may not be labeled as that when you sign them. They could also be blended together. For example, you could have an NDA that includes non-compete and non-solicitation language in it. It's not the label or the title of the document that's important. It's the language, the clauses that appear in there. So if you've signed something that has the non-compete clause, that has a non-solicitation clause even if it's called an NDA, you're still going to be bound by that language. So beware, just because you think you signed an NDA, you might have actually signed more than just an NDA. Now, the fourth legal issue you need to be aware of is called work for hire or works made for hire. This is a little known area of the law that is actually incredibly powerful. It applies very narrowly to work that is copyrightable. What makes something copyrightable? There's a three-part test. First, it must be original. It must be independently created. So it can't be something that you've copied from someone else. It has to be your own creation. It must also show creativity. In the legal languages, it must show at least a modicum of creativity. And the definition of a modicum of creativity basically means a very little bit, is something beyond mere labor, skill, or effort. For example, if you came up with a list of names and phone numbers, kind of like the old-fashioned white pages in the phone book, and you published that list, that would not be something that's copyrightable because the law would say there's really no creativity there. So it must show at least a little bit of creativity that goes beyond just labor, skill, or effort. It must also be fixed in a tangible medium of expression. What does this mean? Well, if you have an idea floating around in your head, that is not fixed in a tangible medium of expression. That is not something that's copyrightable. However, if you take that idea and you write it down on a piece of paper, that is fixed in a tangible medium of expression. So it could be something like something you designed in Photoshop and saved to disk. It could be a musical idea that you had that you recorded as an MP3. Those would be things that are fixed in a tangible medium of expression. It must also be a work of authorship. Now, works of authorship are things like literary works, musical works, pictorial, graphic, and sculptural works, audiovisual works, sound recordings, and the like. For example, software code, if you've written software code, that is considered a literary work, and that would make it something that's copyrightable. So, under the works made for hire doctrine, could you reuse software code written for one company while doing work for another company? Well, the answer is, it depends. Generally speaking, if you've written the software in an employer-employee relationship, the answer is no. You cannot reuse that in work for another company, or if you're doing a side hustle and doing consulting, you're not allowed to use that code for another company, for your client. However, if you've done work as a contractor or a consultant for a company, in order for that to be considered a work made for hire, it must meet a 9-part test, and it must be expressly written in the agreement as a work made for hire. Now, what's the 9-part test? The 9-part work for hire test is, it must be either a contribution to a collective work, part of a motion picture or other audiovisual work, a translation, a supplementary work, a compilation, an instructional text, a test, answer material for a test, or an atlas. Now, some of those may seem a little random, especially the atlas. I don't know why, the atlas. But if it doesn't fall into one of those categories and not expressly stated in an agreement as work made for hire, work that you've done for a client as a contractor or consultant would not be considered a work made for hire, and you would be able to use it in your other work for other clients. Now, the 5th legal area that you must understand is the business entity. What is a business entity? A business entity is something that allows you to do business that is separate from yourself. The simplest way to start out in business is just as yourself. That's what's called being a sole proprietor. A sole proprietor is when you would just go out, get a client, get a project, complete the project, and get paid for the project directly from your client. In that case, you're acting as a sole proprietor. It's just you doing business as you. Now, in most areas, you can just go out and do that. Or depending on the kind of work you do, you may need to get a business license. Now, if you didn't want to use your personal name and you wanted to have a company name, for example, if I were to do business as a sole proprietor, I would do business as Brandon Michaels. If I didn't want to do business as my name, let's say I wanted to do business as something like Superb Software Services. So if I wanted to do business as Superb Software Services, I would need to file something called a DBA. DBA stands for doing business as. This could also be called an assumed name certificate. Now, what you would do to file the DBA, depending on where you live, you either go to your county or you go through your state, and you would probably start with a name search to make sure there's no other company using that name. And if you're able to get that name, you would file a DBA, pay a nominal fee. Now you would have the right to hold yourself out as that name, whatever the company is. So I would have the right to do business as Superb Software Services. Now, if I wanted to form a business entity, one of the most common ways is to form an LLC, or a limited liability company. This is something you would form through your state. And what it would do is it would limit your liability, limit your exposure to the assets that are in your business. So for example, if something happened and someone came after you for money, they could get to the assets that are in your business. They could get to the assets that are in your LLC, but they couldn't get all the way through to your personal assets. So forming an LLC and doing business as an LLC is something that allows you a certain amount of protection. An LLC can be either single member or a multiple member. So if you were a sole proprietor and you wanted to have some limited liability protection, you could form a single member LLC and you would achieve the limited liability, but you would still operate primarily as a sole proprietor. Now, the next step up from that would be to form something called an S corporation. An S corporation would also provide limited liability, will also limit your exposure. It's just a little bit more involved to set up in terms of cost, in terms of effort. It would take a little bit more to form an S corporation. Now, depending on your income, an S corporation could provide some tax savings, at least above a certain income threshold. And maybe the best of both worlds is that as an LLC, you can actually elect to be taxed as an S corp. The interesting thing about LLCs is that the IRS doesn't really recognize them as a separate entity. Even though the rest of society and the law recognizes an LLC as a separate business entity, the IRS does not. The IRS, if you're a single member, will tax you as a sole proprietor, and if you're a multiple member, will tax you as a partnership. So for the purposes of the IRS, for the purpose of taxation, the LLC is considered a disregarded entity. However, if you elect to have your LLC taxed as an S corp, then it would be seen as a corporation. In that case, you would literally need to do a separate tax return. One of the benefits of having a single member LLC is you can file your taxes right in your normal tax return. You just put your income and expenses on your Schedule C. However, if you have an LLC that's elected to be taxed as an S corporation, now you have to file separate corporate taxes. And the sixth legal issue you need to be aware of before you start your consulting business is the concept of piercing the corporate veil. If you formed an LLC or corporation, the important thing to remember is this does not protect you from everything and anything. There are still cases in which you could have personal liability, and this is called piercing the corporate veil. For example, if you're carrying on business and you do something illegal, you are always going to be liable for that, whether or not you formed an LLC or a corporation. Also, if you commit negligence and you end up causing damage or hurting someone, you are going to be personally liable for that. The LLC, the corporation, is not going to protect you from negligence. Now, the negligence test is basically what would a reasonable person do under the circumstances. So in the case of negligence, if the court determines that you've done what a reasonable person would do under the circumstances, then you would preserve your protection with the LLC. However, those are not the most common areas where you would not have protection through your LLC or S corporation. One of the more common areas is something called commingling. And commingling means to mix your business and your personal finances. This could mean, for example, paying for personal items out of your business account, or receiving checks, receiving payments from clients into your personal banking account. These are things that would be considered commingling. And commingling is one of the main reasons why a court would be able to pierce the corporate veil. They would be able to go through your LLC and get to your personal assets. Now, to avoid commingling, one of the most important things to do is to set up a business bank account and make sure that you receive your business income and you pay your business expenses out of that business bank account. Now, another situation where piercing the corporate veil could occur is if you're not following formalities. Not following formalities could be something like not paying dividends, or not keeping good business records, or not holding shareholder meetings. Another instance of not following formalities would be if you start to use variations of your company name instead of using the company name that you actually registered the company with. Now, the seventh legal area that you need to be aware of before you start your consulting business is the area of estimated taxes and deductions. If you have only ever been an employee, you may or may not know that your employer withholds income taxes from your paycheck. So when you get to the end of the year and it's time for tax time, you may owe a little bit or you may get a little bit of a refund. But for the most part, you're pretty close to having already paid your income taxes. Your clients will not withhold any income taxes when they pay you for a project. That means you need to allocate money, set aside money to pay your taxes. In this case, taxes are going to seem like a lot more because before, when you were just an employee, you never really saw the money. It came out of your paycheck. You only basically saw what was coming into your bank account. In this case, you're going to have to pay the full amount of those income taxes. And the way that works is you end up paying them through quarterly payments. So on tax day, April 15th or around there, June 15th, September 15th, and then January 15th for the final quarter from the previous year, you owe estimated taxes. If you don't pay them timely and you don't pay enough, you'll be subject to penalties when you actually file your tax return. Now, one incredibly important area of taxes when you're doing freelance consulting is the area of tax savings. And by tax savings, what I'm specifically referring to are deductions. Deductions would be primarily business expenses that allow you to reduce your income. For example, if you start your freelance consulting business and over the course of the next year, you spend $5,000 on equipment and some training in order to start up your business and build the skills that you need to have, you can then take that $5,000 you spent, itemize your deductions on your tax return, and that will literally reduce your income by $5,000, which means you'll pay taxes on less money. Now, in order to do this, it's really important to document all of your expenses. Keep your receipts, save the PDFs, grab the screenshots, keep the physical receipts of there. Make sure that you keep these all in a folder, and it'll be also good to put them onto a spreadsheet so you're tracking them as the year goes on. Because at the end of the year, it's an awful lot of work to add them all up if you haven't been doing it as you go along. So again, you could spend money on equipment, maybe travel, maybe you go to a business conference, maybe you're going to a marketing conference to learn how to market your business, or a sales conference to learn how to sell better. Maybe you invest in some training that's going to help you level up in learning how to be a consultant and what you need to do to grow your business. The important thing to remember about investing money in this way, because it's going to be a deduction, because it's reducing your income, you're literally not paying the full amount for that training, for that equipment, for that travel. Because it's reducing your income and therefore reducing your taxes, you're effectively not paying the full amount for those things you've invested in. Another great way to reduce your taxes, in addition to deducting business expenses, is to start something like a solo 401k. This also is going to allow you to reduce your income by the amount that you invest in your 401k. Now, another way you can reduce your taxes, let's say you're doing your freelance consulting, you're starting out as a side hustle. And let's say you start out the first year, you start towards the end of the year, maybe you get an $8,000 project, but you've spent $10,000. Let's say you spent the $5,000 on the equipment, on the laptop, and the travel, and then maybe you invest another $5,000 in some business coaching. At that point, if you've only made $8 and you invested $10, you're going to have a $2,000 loss. You can actually deduct that against your W-2 income and reduce your taxes. Thank you so much for watching, and I'll see you in the next video.